Got it? A very good afternoon to all of you. I welcome you all in this live lecture. My today's topic is emerging dimensions of fundamental right in present scenario. Uh, Today, I would like to give you the introduction. So I would like to start with the origin of fundamental rights. So first of all, I would like to tell you that Magna Carta is the first written document in 1215 related to the fundamental rights of the citizens. American were the first to give Bill of Rights a constitutional status. When the Constitution of India was being framed, the Constitution maker took inspiration and incorporated the full chapter which discussed about the fundamental rights. So when we talk about the development of constitutional rights in India. So it was inspired by the historical documents such as England Bill of Rights, the United States Bill of Rights, and France Declaration of the Rights of Men. So in the next, coming to the next slide, which is meaning of fundamental right. So fundamental right are the basic human right enshrined in the Constitution of India, which are guaranteed to the all citizens. They are applied without discrimination on the basis of race, religion, gender, etc. Significantly, fundamental rights are enforceable by the court subject to the certain conditions. So, uh, in the next slide, I would like to tell you that what are the need for fundamental rights. ऐसी क्या जरूरत पड़ी हमें fundamental rights की? Fundamental rights जो है इतने important क्यों हुए और क्या हमें जरूरत पड़ी कि हम fundamental rights का एक पूरा का पूरा chapter अपने constitution में दें? So in the first point, it is there to protect the citizen against the power delegated by them to the government, to preserve public and private right of the individual, to protect the dignity of individuals, to establish a rule of law, not of men. And next one is to provide certain standards of conduct, citizenship, justice, and perfect equality between the society. So when we talk about the needs of fundamental right, I would also like to discuss the features of fundamental rights here. So the number one is fundamental rights are differently from ordinary legal rights in the manner in which they are enforced. Like if a legal right is violated, the aggrieved person can't directly approach the Supreme Court bypassing the lower court. But in the case of fundamental right, aggrieved person can go directly to the court in Article 32 in this Supreme Court in Article 32 and High Court in Article 226. So the second point is some of the fundamental rights are available to all citizens, while rest are for all persons. Next is the fundamental rights are not absolute rights. They have reasonable restrictions, which means that they are subject to the condition of state security, public morality, and decency. Fundamental right can be amended by the parliament by a constitutional amendment, but only if the amendment doesn't alter the basic structure of the constitution. Fundamental right can be suspended during a national emergency, but the right guaranteed under the Article 20 and 21 cannot be suspended. So the applicability of fundamental right can be restricted in an area that has been placed under military rule. तो जहाँ भी military rule लगता है या presidential rule लगता है वहाँ पे fundamental rights जो है वो suspend कर दिए जाते हैं, जैसे कि हमने last point में देखा कि suspension सारे फंडामेंटल राइट जो है सस्पेंड कर दिए जाते हैं, लेकिन आर्टिकल 20 और आर्टिकल 21 जो है वो सस्पेंड नहीं किए जाते हैं. सो फंडामेंटल राइट्स जो है सिटीजन्स को अवेलेबल है और नॉन सिटीजन्स को भी अवेलेबल है, लेकिन कुछ फंडामेंटल राइट्स ऐसे हैं जो सिर्फ सिटीजन्स को अवेलेबल है. सो आई वुड लाइक टू डिस्कस दोस फंडामेंटल राइट्स. दैट नंबर वन इज आर्टिकल 15 which talks about the prohibition of discrimination on the basis of religion, caste, gender, race, place of birth. Second one is equality of opportunity in matter of public employment, which is given in Article 16. Next one is Article 19, which talks about the protection of freedom of different kinds, like freedom of speech and expression, freedom of association, freedom of assemble peacefully, freedom of movement, freedom of residence, and freedom of trade and commerce also. Next one is Article 29, which talks about the protection of culture, language, and script of minorities. And the next one is Article 30, which is right of minority to establish and administer educational institutions. Here comes the next question, that the fundamental rights can be amended or not. So fundamental right can also be amended. Any changes to the fundamental right require a constitutional amendment that should be passed by both the houses of parliament. As per the constitution, article 32 13 clause 2 states that no law can be made that takes away fundamental right. Uh, we all know that in the landmark judgment of Keshwan and Bharti versus State of Kerala 1973, Supreme Court held that the fundamental right can be amended, but the basic structure of the fundamental rights cannot be abrogated even by the constitutional amendment. So coming to the next slide, as we all know that we have six fundamental rights given under the Indian Constitution. Number one is right to equality, which is given in Article 14 to 18. So, right to equality guarantees equal right for everyone, irrespective of religion, gender, caste, race, or place of birth. It ensures equal employment opportunities in the government and ensures against discrimination by the state in matter of employment on the basis of caste, religion, etc. This right also includes the abolition of titles as well as untouchability, which is given in Article 17. So coming to the next right, which is right of freedom of different kinds, which is given in Article 19 to 22. So freedom is one of the most important ideal cherished by any democratic society. The Indian Constitution guarantees freedom to citizen. So there are freedom includes in many rights like freedom of speech and expression, freedom of assemble without arms, freedom of association, freedom to practice any profession, freedom to reside in any part of the country. So some of these rights are subject to certain conditions of state security, public morality, decency, and friendly relation with foreign countries. This means that the state has the right to impose reasonable restrictions on them. So coming to the next article, which is right against exploitation, next right, which is right against exploitation, which is given in Article 23 to 24, which talks about that the prohibition of trafficking in human being, beggar, and other form of forced labor. It also implies the prohibition of children in factories, etc. The Constitution prohibits the employment of children under 14 years in hazardous condition. So next one is right to freedom of religion, that is given in Article 25 to 28. This indicates the secular nature of Indian polity. There is equal respect given to all religion. There is freedom of conscience, profession, practice, and propagation of religion. The state has no official religion. Every person has the right to freely practice his or her faith, establish and maintain religious and charitable institutions. Coming to the next one, cultural and education right, which is given in Article 29 and 30. That is, these rights provide the right of religion, culture, and linguistic minorities by facilitating them to preserve their heritage and culture. Educational rights are for ensuring education for everyone without any discrimination. And last one is right to constitutional remedies, which is given in Article 32. So the Constitution guarantee remedy if citizens' fundamental rights are violated, and the government cannot infringe upon or curb anyone's right. When these rights are violated, the agree party can directly approach to the Supreme Court, and in these cases, Supreme Court can issue the writ for enforcing fundamental right of the person. So these are the basic explanation. ये बेसिक एक्सप्लेनेशन थी फंडामेंटल राइट्स की. एकदम बहुत ज़्यादा डीप नहीं था, लेकिन बेसिक्स ही मैंने इंट्रोडक्शन दिया फंडामेंटल राइट्स का. सो इसी बीच में मैं आर्टिकल 21 को लाना चाहूँगी कि आर्टिकल 21 कितना इंपॉर्टेंट है और आर्टिकल 21 का क्या मायने है. सो फर्स्ट ऑफ ऑल मैं आर्टिकल 21 की बेसिक लैंग्वेज जो है वो रीड आउट करना चाहूँगी कि आर्टिकल 21 विच टॉक्स अबाउट दैट नो पर्सन शैल बी डिप्राइव्ड ऑफ हिज लाइफ और पर्सनल लिबर्टी एक्सेप्ट अकॉर्डिंग टू द प्रोसीजर एस्टैब्लिश्ड बाय लॉ. सो आर्टिकल 21 की जब हम बात करते हैं तो आर्टिकल 21 दो प्रपोजिशंस के ऊपर काम करता है. नंबर वन इज राइट टू लाइफ एंड द सेकेंड वन इज राइट टू पर्सनल लिबर्टी. सो आर्टिकल 21 में जो वर्ड लाइफ है वो कितना इंपॉर्टेंट है उसे देखते हैं. कि life in Article 21 of the Constitution is not merely the physical act of breathing. कॉन्स्टिट्यूशन में जो लाइफ की बात कही है वो जस्ट अ फिजिकल एक्ट ऑफ ब्रीदिंग नहीं कह रहा है, वो कि एक जस्ट एक ब्रीदिंग करना ही लाइफ नहीं है, उसके अलावा उसके बहुत डीप डायमेंशन है, उसकी डीप मीनिंग है बहुत ज्यादा। आगे देखते हैं, इट डज नॉट कनोट मेरीली एनिमल एग्जिस्टेंस और कंटिन्यू ड्रगरी थ्रू लाइफ, it has a much wider including the right to live with human dignity, right to livelihood, right to health, right to pollution free environment, and lot more. So the right to life is a fundamental to our very existence, without which we cannot live as human beings, and include all those aspects of life which make a man's life meaningful, complete, and worth living. It is the only article in the constitution that has received the broadest possible interpretation. हम अभी भी देखते हैं कि आर्टिकल 21 डे बाय डे कितना इंटरप्रिटेट किया जा रहा है। सो वही ये बात कह रहे हैं कि आर्टिकल 21 कितना ब्रॉडर है। ये चीज आर्टिकल 21 अपने आप में एक आर्टिकल 21 के ऊपर तो अपने आप में एक बुक लिखी जा सकती है, तो आर्टिकल 21 अपने आप में एक ब्रॉड इंटरप्रिटेशन है। सो द बेयर नेसेसिटी मिनिमम एंड द बेसिक रिक्वायरमेंट फॉर अ पर्सन फ्रॉम द कोर कंसेप्ट ऑफ द राइट टू लाइफ. So the right to life is undoubtedly the most fundamental of all the rights. All other rights add quality to the life in question and depend on the pre-existence of life itself for their operations. As a human right can only attach to living beings, one might expect the right to life itself to be in some sense primarily, since none of the other right would have any value or utility without it. So here is the case of खड़क सिंह वर्सेस स्टेट ऑफ उत्तर प्रदेश, जिसमें सुप्रीम कोर्ट ने जो है टर्म लाइफ को लाइफ के बारे में अपनी एक ऑब्जर्वेशन बताई थी, जो कि मैं रीड आउट करना चाहती हूँ एज इट इज. बाय द टर्म लाइफ एज हियर यूज्ड, समथिंग मोर इज मीन देन मेरी एनिमल एग्जिस्टेंस. सिर्फ एनिमल एग्जिस्टेंस नहीं, उससे बहुत ज्यादा राइट टू लाइफ का इतना इंपॉर्टेंस है. द इनहैबिटेशन अगेंस्ट इट्स डेप्रिवेशन एक्सटेंड टू ऑल दोज लिम्स and facilities by which life is enjoyed. The provision equally prohibits the mutilation of body by amputation of an armored leg, or by pulling out of an eye, or the destruction of any organ or the body through which the soul communicate with the outer world. In the same way, Sunil Batra versus Delhi administration में भी सुप्रीम कोर्ट ने अपने ऑब्जर्वेशन को अप्रूव रखा था. In this case, Supreme Court held that right to life include the right to lead a healthy life, to enjoy all facilities of human body in their private condition. It would even include the right to protect a person's tradition, culture, heritage, and all that give meaning to a man's life. So coming to the next slide, here are some landmark judgment which talks about the emerging dimensions of right to Article 21, which is right to live with human dignity. In Menka Gandhi versus Union of India, the Supreme Court gave a new dimension to Article 21. The court held that the right to live is not merely a physical right, but also includes right to live with human dignity. So in another case, which is Bandhua Mukti Morcha case versus Union of India, there is a case which is called Bandhua Mukti Morcha versus Union of India, which is also characterized that Article 21 as the heart of fundamental right, and court also gave it an expanded interpretation. So in this case, Justice P.N. Bhagwati observed that it is the fundamental right of everyone in this country to live with human dignity, free from exploitation. The right to live with human dignity enshrined in Article 21 drive its life breath from the directive principles of state policy, and particularly clause E and F of the Article 39 and Article 41 and 42. So coming in this series, coming to the next case, which is right against sexual harassment at workplace. So sexual harassment of women has been held by the Supreme Court to be violative of the most cherished of the fundamental right, namely the right to life contained in Article 21. The meaning and content of the fundamental right guaranteed in the Constitution of India are of sufficient amplitude to compass all the facts of gender equality, including prevention of sexual harassment. There is a case also, Vishakha versus State of Rajasthan, in which the Supreme Court declared sexual harassment at workplace to be the violate the right to equality, life, and liberty. Therefore, a violation of Article 14, 15, and 21 of the Constitution. In this case, in the absence of a relevant law against sexual harassment, the Supreme Court laid down the following guidelines to ensure gender parity at the workplace. Uh, इसी बीच में मैं एक चीज और ऐड ऑन करना चाहूंगी कि ये गाइडलाइन सुप्रीम कोर्ट ने दी थी सेक्सुअल हरासमेंट एट वर्क प्लेस, जब हमारे पास कोई लॉ नहीं था सेक्सुअल हरासमेंट से रिलेटेड। सो सेक्सुअल हरासमेंट से रिलेटेड हमारे पास एक एक्ट आया 2013 से, उससे पहले यही गाइडलाइंस थी जो सुप्रीम कोर्ट ने ले डाउन की थी, जिन पे हम जिन पे हम मैं भी जिन पे बात करना चाह रही हूँ। So the number one is express prohibition of sexual harassment as defined above at the workplace should be notified, published, and circulated in appropriate ways. The rules, regulation of government and public sector bodies relating to the conduct and disciplines should include rules regulating prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. The victim of sexual harassment should have the option to seek the transfer of perpetrator or their own transfers. Where such conduct amount to specify offense under IPC or under any other law, the employer shall initiate appropriate action by making a complaint with the appropriate authorities. As regard private employers, step should be taken to include the prohibition above the standing orders under the Industrial Employment Act 1946. So in this series, right to livelihood is also included in the right to life. There is a case of Olga Tellis versus Bombay Municipal Corporation, which is popularly known as a pavement dweller case. In this case, Supreme Court observed that the sweep of right to life conferred by Article 21 is wide and far-reaching. It doesn't mean merely that the life cannot be extinguished or take away, as for example by imposition and execution of death sentence, except according to the procedure established by law. That is but one aspect of the right to life. An equally important aspect of the right to life is the right to livelihood, because no person can live without the means of livelihood. So in the series, there are a lot more cases related to just a minute, related to right to clean environment, which talks about the right to life under Article 21 means a life of dignity, to live in a proper environment free from danger of diseases and infections, maintenance of health, and preservation of the sanitation and environment have been held to fall within the purview of Article 21, as it adversely affects the life of citizen, and it amounts to slow poisoning and reducing the life of the citizen because of the hazards created if not checked. So there are some cases related to MC Mehta also. Just a minute. Yes. There is case of MC Mehta. The Supreme Court ordered the closure of tanneries polluting the water. In another case of MC Mehta versus Union of India 1997, the Supreme Court issues several guidelines and directions for the protection of Taj Mahal, an ancient monument, from environmental degradation. In the case of Murli S. Devra versus Union of India, the person not indulging in smoking can be compelled to or subjected to passive smoking on the account of act. Therefore, right to life under Article 21 affected as a non-smoker may become a victim of someone smoking in a public place. MC Mehta versus there is one more case of MC Mehta versus Union of India. The court held that the large-scale misuse of residential premises for commercial use in Delhi violated the right to a decent environment. Taking note of the problem, the court issued directive to the government on the same case. So here is also a well-known case of Vellore Citizen Welfare Forum versus Union of India. The court took cognizance of the environment problem being caused by the tanneries that were polluting the water resources, rivers, canals, underground water, and agricultural land. As a result, the court issued several directions to deal with all of these problems. So that's all for now. Thank you.